If you own a gun in America, everything just changed this February, and I'm not exaggerating for effect. A federal ruling rewrote gun laws nationwide, affecting all 50 states, and most gun owners have absolutely no idea it even happened. 10 massive legal changes just went into effect. Law number 10 is so explosive that 3 states are openly threatening outright rebellion against the federal judiciary. And here's what should terrify you. Missing this information could cost you your guns, your freedom, or both. We're not talking about theoretical legal debates or bills stuck in committee that might pass someday. We're talking about enforceable rulings that changed what's legal and what's a felony overnight in February 2026. Constitutional carry recognition across state lines, red flag law due process requirements, privately made firearms restored, magazine capacity bans struck down, suppressor deregulation, private sale documentation eliminated, assault weapon definitions narrowed, vehicle castle doctrine expanded, firearms taxation restricted, and mass confiscation orders ruled unconstitutional. Each one of these changes affects millions of gun owners, and if you don't understand what just shifted, you could find yourself on the wrong side of the law without even knowing the rules changed, or worse, you could fail to exercise rights you didn't know you just gained back. Hit that subscribe button right now, because 90% of gun owners are going to miss these critical updates entirely. And the difference between knowing these laws and missing them could mean the difference between staying free and facing felony charges tomorrow. Drop a like if you want more coverage of legal changes that actually matter instead of clickbait speculation. And comment below with which of these 10 changes affects you most directly, because this community needs to understand what just happened and how to use these protections. The landscape just shifted under everyone's feet, and most people are still operating under rules that no longer exist. Let's start with the first change that flips everything upside down for gun owners living in constitutional carry states. Right now, 29 states allow you to carry a concealed firearm without any permit whatsoever. You don't need paperwork. You don't need government permission. You just carry, period. But here's the problem that's been destroying people's lives for years. The second you cross an invisible line into a state that requires permits, you become a criminal carrying the exact same gun that was perfectly legal 5 minutes ago. And the consequences aren't theoretical warnings. They're real arrests, real jail time, real financial devastation for people who had no criminal intent whatsoever. A construction worker from Idaho drove to Oregon for a job last year and got pulled over for a broken taillight. Simple traffic stop. He told the officer about his concealed pistol, which was completely legal in Idaho without any permit. He was being responsible, trying to do the right thing. He spent 2 nights in jail. He paid $4,800 in bail. He burned through $11,000 in legal fees before the prosecutor finally dropped the charges 8 months later. 8 months of his life consumed by legal hell because he crossed a state border with a firearm that was legal in his home state. The February ruling says that nightmare is over. If your home state recognizes constitutional carry, you can now travel to 42 other states and carry concealed without getting a permit from anyone. Your constitutional carry status travels with you across state lines the same way your driver's license does. This is massive for millions of gun owners who travel for work, for family, for any reason, because it eliminates the patchwork chaos of reciprocity agreements that nobody could keep straight and that turned law-abiding citizens into accidental felons. But here's what nobody's talking about yet, and this is critical. Carrying legally doesn't mean anything if the government can still grab your guns based on nothing but someone's accusation. And that brings us directly to the second major change that just shattered how red flag laws operate across America. Red flag laws have been the most dangerous tool for stripping away gun rights without any crime being committed, without any conviction, without any due process worth the name. 21 states passed laws allowing judges to confiscate your firearms based on a petition from almost anyone. An angry ex-partner, a worried neighbor, a co-worker you had an argument with last week. And here's the part that made these laws absolutely terrifying. You never got to defend yourself before your guns disappeared. The government took your property first and maybe gave you a chance to argue about it later, inverting every principle of American justice. A high school teacher in Colorado had every firearm in his house seized after a student's parent filed a petition claiming he talked about guns too much in class. Read that again. Talked about guns too much. No threats were made. No investigation happened. No evaluation of whether the claim had any merit. A judge signed the order in a 10-minute hearing, and police showed up at his house that same afternoon and took every gun he owned. It took him 13 months and $22,000 in attorney fees to get his property back. 13 months, $22,000, for exercising his First Amendment rights and owning firearms legally. The new ruling from February says this ends immediately, and the changes are significant enough that they gut the most abusive aspects of red flag laws while still allowing emergency intervention in genuinely dangerous situations. Before any judge can authorize taking your firearms, you must be notified of the petition against you. You get to appear in court, you can bring an attorney, you can present evidence, you can cross-examine whoever's making the accusation. If there's an emergency order where they take your guns first because there's an imminent threat, you automatically get a full hearing within 72 hours to challenge the confiscation, not 72 business days. Not whenever the court gets around to scheduling it. 72 hours. That's a fundamental shift from the way these laws operated before, where people waited months to get their day in court while their constitutional rights were suspended based on accusations that might have been completely fabricated. Now, even with these new protections in place, understand that the government has been targeting another category of firearms they claimed you had zero right to own, and that attack just crashed and burned spectacularly. The ATF's crusade against privately made firearms, what they derisively call ghost guns, just got destroyed by the February ruling, and the legal reasoning demolishes the regulatory framework the Biden administration tried to impose. Back in 2022, the ATF rewrote the definition of what legally counts as a firearm. And overnight, pieces of metal that required hours of drilling, milling, and machining to become functional suddenly got classified as firearms requiring serial numbers and background checks. They targeted 80% frames and receivers, which are unfinished chunks of aluminum or polymer that cannot fire anything until you complete serious mechanical work to make them operational. A retired machinist in Pennsylvania built AR-15 rifles from 80% lowers as a hobby for 22 years. This was his retirement activity. He wasn't selling them. He wasn't committing crimes. He was building firearms for himself, which had been completely legal for the entire history of America until the ATF decided to rewrite the rules. ATF agents raided his home in January 2024, confiscated 31 firearms, and charged him with manufacturing firearms without a federal license. He's 68 years old and was facing up to 10 years in federal prison for a hobby that was completely legal when he started it and remained legal for 2 decades until the government suddenly changed the definition. The February court decision destroys the ATF's new rules completely and entirely. The judges said something that should have been obvious from the beginning. An unfinished frame or receiver is not a firearm until it actually works as a firearm. You have the constitutional right to build guns for yourself without serial numbers, without registration, and without asking permission from any government agency. This ruling affects millions of unfinished frames and receivers that gun owners purchased legally, but that the ATF tried to retroactively criminalize. And it restores a right that Americans have exercised since before the country was even founded. But what you build is only half the story. What you put inside those firearms, specifically the magazines that hold ammunition, just became equally protected under the February ruling, and the reaction from gun control politicians has been absolute chaos. The plastic box that holds your ammunition just went from illegal contraband in 10 states to constitutionally protected property nationwide, and states that built entire enforcement apparatus around magazine bans are now watching those laws collapse. California, New York, New Jersey, Massachusetts, Colorado, Connecticut, Hawaii, Maryland, Washington, and Vermont all banned magazines holding more than 10 rounds, claiming these restrictions would reduce crime, even though there's zero statistical evidence supporting that claim. Here's the absurdity this created. The Glock 17, which is the single most popular handgun in America, comes standard from the factory with a 17-round magazine. A military veteran in Massachusetts bought a Glock 19 legally at a gun store. The salesman removed the 15-round magazines that come standard with the pistol and sold him 10-round magazines instead to comply with state law. 6 months later, the veteran was moving to New Hampshire and found the original 15-round magazines in a box in his basement. The previous owner of the gun must have kept them. He didn't even know they were there. A state trooper pulled him over for speeding and searched his car during the stop. He got arrested and charged with illegal possession of high-capacity magazines, and the district attorney wanted 18 months in jail, 18 months in prison for possessing magazines that came standard with the gun from the manufacturer. The February ruling says magazines holding 11 to 30 rounds are standard capacity and in common use by tens of millions of law-abiding Americans across the country. Banning them violates the Second Amendment. This doesn't just affect new purchases. This affects magazines people already own, magazines they inherited, magazines they bought legally years ago that states then tried to criminalize retroactively. Millions of magazines that were illegal contraband yesterday are constitutionally protected property today. Yet there's another firearm accessory that's been even more demonized by Hollywood and politicians, the one they convinced Americans was only used by assassins and criminals, and that just became as easy to buy as the gun itself. Suppressors, the hearing protection devices that movies turned into sinister silencers used by hitmen, just became deregulated nationwide, and the explosion in demand is already overwhelming manufacturers who spent decades operating in a tiny niche market. Since 1934, suppressors have been trapped under the National Firearms Act alongside machine guns and destructive devices, creating a regulatory nightmare that had nothing to do with public safety and everything to do with making ownership as difficult as possible. To legally buy a suppressor, you had to submit fingerprints and passport photos, notify local law enforcement, pay a $200 tax to the federal government, and then wait. And wait. And wait some more. The approval process routinely took 8 to 12 months. Only 2.9 million suppressors were registered in a country with over 425 million firearms. That's one suppressor for every 146 guns, which shows how effective the regulatory burden was at preventing people from accessing hearing protection. A farmer in Nebraska applied for a suppressor in April 2023 because he needed to protect his hearing while shooting prairie dogs that were destroying his crops. He paid $850 for the suppressor and $200 for the tax stamp. He received approval in February 2024, 10 months later. By the time the government gave him permission to protect his hearing, he already had permanent hearing damage in his right ear from shooting without the suppressor he'd been waiting on for nearly a year. The February ruling rips suppressors completely out of the National Firearms Act. Buying a suppressor now works exactly like buying a regular firearm. Instant background check through the NX system, and you walk out with it the same day. No tax, no waiting period, no photographs or fingerprints. This is going to transform the suppressor market and finally allow Americans to protect their hearing the way shooters in European countries have been doing for decades, because in most of Europe, suppressors aren't regulated at all. They're considered basic safety equipment. If you want to comment below and share whether you've ever wanted to buy a suppressor but didn't because of the regulatory hassle and cost, I want to hear about it. Because this is a perfect example of government making constitutional rights as expensive and difficult as possible without outright banning them. But getting the suppressor was only part of the problem gun owners faced. The nightmare of paperwork and potential felony charges every time you wanted to loan, sell, or transfer any firearm was just as bad, and that barrier just got eliminated entirely. Selling a rifle to your brother, giving your daughter her first handgun as a gift, loaning a shotgun to your hunting buddy for the weekend, all of these normal activities between law-abiding people just went from potential federal felonies to constitutionally protected private transactions, and the universal background check agenda that gun control groups spent billions of dollars pushing just died. 11 states passed laws requiring every single firearm transfer, even temporary loans between friends, to go through a licensed dealer with a background check and a fee. Washington, Oregon, Colorado, Nevada, California, New York, New Jersey, Connecticut, Delaware, Maryland, and Rhode Island all made it illegal to hand your gun to anyone without government involvement and documentation. A grandfather in Colorado gave his grandson a .22 rifle for the grandson's 21st birthday. It was a family rifle that had been passed down for 3 generations. The grandfather didn't know Colorado had changed the law in 2013 requiring all transfers to go through dealers. 2 years later, the grandson mentioned the gift to a coworker who happened to also be a reserve police officer. That officer reported the illegal transfer to authorities. Both grandfather and grandson were charged with unlawful transfer and unlawful possession. A family tradition that had continued for 3 generations became a criminal case because the government decided private citizens couldn't be trusted to transfer property without state supervision. The February ruling says private transfers between lawful gun owners cannot be regulated by the government at all. This affects an estimated 5 million private gun sales and transfers that happen every year in America, and all of them are now legal without paperwork, without government involvement, without fees, and without creating a registry of who owns what. This is a massive shift back toward the way firearm transfers worked throughout most of American history, before states decided they needed to track every transaction and turn family gifts into potential crimes. But there's a term that's been weaponized to ban entire categories of firearms based on how scary they look rather than how they function, and the definition of that term just got absolutely demolished by the courts. The scary-looking rifle that politicians spent 30 years trying to ban based on cosmetic features, the so-called assault weapon, just got protected by a court ruling that destroys the entire foundation of assault weapon legislation across the country, and the legal reasoning makes it nearly impossible for states to revive these bans in any form. 9 states banned firearms they labeled assault weapons based on cosmetic features that have absolutely nothing to do with how the gun actually functions or how dangerous it is. California, New York, Massachusetts, Connecticut, New Jersey, Maryland, Hawaii, Illinois, and Washington made it illegal to own semi-automatic rifles with features like pistol grips, adjustable stocks, flash suppressors, or barrel shrouds. These are ergonomic features. They don't make the gunfire faster, they don't make the bullets more lethal, they don't change the fundamental operation of the firearm. A man in New York owned an AR-15 he legally purchased in 2012. In 2013, the state passed the SAFE Act banning assault weapons. His rifle became illegal overnight not because anything about how it worked changed, but because it had a pistol grip and a collapsible stock. He was required to register it with the state or face criminal charges. In 2023, he sold the rifle to a licensed dealer to get it out of his house and avoid any potential legal problems. 2 months later, state police showed up at his door and arrested him. The registration database had an error, and the system flagged him as owning an unregistered illegal weapon. He spent $18,000 and months of his life proving he had legally sold the gun and no longer owned it. The February ruling declares that bans based on cosmetic features violate the Second Amendment because semi-automatic rifles are in common use for lawful purposes. Over 24 million AR pattern rifles exist in America alone, making them the most popular rifles in the country. You cannot ban firearms in common use. That's settled law going back to Heller, but states tried to get around that by redefining common rifles as assault weapons based on features that don't affect lethality. The court just said that game is over. Still, owning these rifles is one thing. Using them to defend yourself in your vehicle just got massively more legal protection, and this change could save you from a murder charge if you're ever forced to defend yourself while traveling. Your car just became legally equivalent to your home under Castle Doctrine protections, and if you ever have to use deadly force to defend yourself while in your vehicle, this change transforms the legal standard prosecutors use to evaluate whether you committed a crime. Most states had Castle Doctrine laws protecting you from prosecution when you use deadly force to defend yourself inside your house. The doctrine says you have no duty to retreat when attacked in your own home. You don't have to run away or try to escape before defending yourself. Those protections evaporated completely the moment you stepped into your car, and prosecutors used that gap to destroy people who defended themselves against violent attackers. A pizza delivery driver in Michigan was making a delivery at 11 at night when a man approached his car window and pointed a gun directly at him while demanding money. The driver drew his concealed carry pistol and shot the armed robber. The robber survived. The driver got arrested and charged with assault with a deadly weapon because prosecutors argued he could have thrown the pizza and his wallet out the window and driven away rather than using his gun. He had to prove he had no reasonable avenue of escape before he was legally justified in defending himself against an armed robber pointing a gun at his face. He spent 19 months fighting the charges before they were finally dropped, but his legal bills hit $67,000. The February ruling extends full Castle Doctrine protection to any occupied vehicle. Your car, your truck, your RV, your motorcycle. All of them are now legally your home for purposes of self-defense law. You have no duty to retreat when attacked in your vehicle. You don't have to prove you couldn't escape. This affects every state with Castle Doctrine laws, which is 38 states, and it means defending yourself in your car has the exact same legal protections as defending yourself in your bedroom. But even with expanded self-defense rights and weapon protections, there was one financial barrier keeping millions of working-class Americans from exercising their Second Amendment rights at all. And that barrier just got struck down as an unconstitutional poll tax on your rights. The hidden taxes and fees that made gun ownership too expensive for working-class Americans just got ruled unconstitutional. And what the government called reasonable regulation, the court called an illegal poll tax designed to price people out of their constitutional rights. States piled fees and taxes on every step of owning a firearm specifically to make exercising your rights as expensive as possible. And they weren't even hiding the intent. Illinois charged $300 for a firearm owner's identification card. You couldn't even buy a gun in Illinois without one, and that $300 fee had nothing to do with the actual administrative cost of running a background check. It was a barrier. New York City charged $340 for a concealed carry permit that expired after 3 years, meaning you paid $340 again every time you renewed. A truck driver in Illinois wanted to buy a handgun after his truck was broken into twice in 6 months. Between the FOID card at $300, the mandatory training course at $150, the background check fee at $35, and the handgun itself at $450, he was looking at $935 total just to exercise a constitutional right. His paycheck couldn't cover it, so he went without the means to defend himself because the government priced him out. A single mother in New York applied for a concealed carry permit after being followed home from work twice in the same month. The application fee was $340. The required 16-hour training class cost $375. Fingerprinting was $91.50. The total came to $806.50 before she even owned a gun, and her application got denied because she couldn't prove proper cause under the subjective standard New York was using at the time. She paid over $800 for nothing. The February ruling says excessive fees and taxes on firearms ownership are unconstitutional infringement. States can only charge the actual administrative cost of processing permits and background checks, which is typically $25 to $40 maximum. This opens gun ownership back up to working-class Americans who were systematically priced out by governments that knew exactly what they were doing when they imposed these fees. And now we get to law number 10, the bombshell that nobody saw coming, and that's already triggered a constitutional showdown between multiple states and the federal judiciary. The government's power to order mass gun confiscations during emergencies, something that actually happened in multiple American cities over the past 20 years, just got ruled completely unconstitutional, and the implications are so massive that several governors are openly discussing whether they'll comply with this ruling or defy it. After Hurricane Katrina destroyed New Orleans in 2005, the city's police superintendent ordered officers to confiscate all firearms from citizens, even from people who hadn't committed any crimes and weren't under evacuation orders. Police went door to door, taking guns from elderly residents who were trying to protect their property from the looters who were ransacking the city. In 2023, after the Maui wildfires devastated parts of Hawaii, the governor signed an emergency proclamation that included language authorizing law enforcement to seize firearms from displaced residents living in evacuation shelters to prevent civil disorder. Police confiscated 147 firearms from people living in temporary housing, people who had just lost everything they owned and desperately needed protection from the theft that always accompanies disasters. A homeowner in New Orleans had his shotgun taken by police during the post-Katrina confiscations. He was 73 years old and staying in his home specifically to protect it from looters who were breaking into abandoned houses across the city. Officers broke down his door, pointed rifles at him, and took his only firearm. He was never accused of any crime. He never threatened anyone. He was protecting his property, and the government disarmed him by force. The February ruling declares that blanket confiscation orders violate the Second Amendment, the Fourth Amendment, and the Fifth Amendment simultaneously. The government cannot suspend constitutional rights during emergencies, period. Mass confiscation orders are explicitly prohibited, regardless of whether the emergency is a natural disaster, civil unrest, or a public health crisis. But here's what makes this law number 10 the most explosive of all the changes. It cuts directly at the heart of government power during chaos, and it tells politicians they cannot use crisis as an excuse to disarm the people when the people need their firearms most. These 10 changes represent the biggest shift in gun rights in decades, affecting everything from carrying across state lines to protection against emergency confiscations during disasters. The difference between knowing these laws and missing them could literally mean the difference between staying free and facing felony charges tomorrow for doing something that's now completely legal. Hit that subscribe button and share this with every gun owner you know, because these protections only work when people actually understand their rights and know how to exercise them. Drop a comment below telling me which of these 10 changes affects you most directly or which one surprised you the most, because this community needs to be informed and ready to defend these gains. The government will try to claw back every inch of this ground if gun owners don't understand what just happened and don't stay vigilant about protecting it.